Section 4, B4. Prologue. Jerusalem, the 11th of April, 1961. A glass booth stands at the center of Beit Ham, not as symbolism but as precaution. Inside sits a man who does not represent ideology as speech, but ideology as administration. Proceedings begin. The charge. Adolf Eichmann is indicted under Israel's 1950 law for the punishment of Nazis and Nazi collaborators. 15 counts: crimes against the Jewish people, crimes against humanity, war crimes, and membership in criminal organizations including the SS, the SD, and the Gestapo. The charges are laid out in the District Court judgment of December 1961 and reaffirmed on appeal on 29 May 1962. The indictment does not accuse him of hatred. It accuses him of coordination. He headed Section 4B4 of the Reich Main Security Office, Jewish Affairs and Evacuation, responsible in practice for scheduling and driving deportations. Evacuation is the word used in memoranda. It does not mean safety. It means extermination. The case is built to test how far responsibility travels through the chain that makes violence scalable. Exhibit A, the machinery. The 20th of January 1942. Wannsee Conference, Berlin. Eichmann attends. The Wannsee Protocol records a Europe-wide final solution as an administrative plan, countries listed, numbers calculated, coordination language made routine. He is not argued as the source. He is presented as the mechanism. The District Court judgment treats this as central, not a battlefield, but transport schedules, negotiations with occupied administrations, and coordination with police authorities. In mass murder, the method is the multiplier. Without the deportation logistics, the plan remains an idea with limits. Not a man in a trench, a man at a desk. The defense. Eichmann testifies in a measured tone, with administrative vocabulary that tries to shrink action into function. He insists he followed orders. He acted within the law of the Reich. He never personally killed anyone. He was a subordinate. He describes himself as a cog in the machine. He does not deny the deportations. He minimizes his agency within them, as if coordination were a kind of absence. The District Court addresses the doctrine of superior orders directly and rejects the claim that obedience or lack of initiative removes culpability for crimes against humanity. Hierarchy is not immunity. The law does not ask whether he hated. It asks what he did, what he knew, and what he enabled. The court finds that Eichmann knew the destinations of the transports and understood the consequences. Verdict: guilty. The appeal. The 29th of May, 1962. Supreme Court of Israel. The appeal reiterates the defense: subordination, absence of policy-making authority, compulsion within a totalitarian regime. The Supreme Court upholds the conviction. It affirms that coordinating deportations with knowledge of their lethal purpose constitutes individual responsibility for crimes against humanity. The reasoning is legal, not rhetorical. The sentence. Just after midnight, on the 1st of June 1962, in Ramla prison, Eichmann is executed by hanging. The body is cremated. Ashes are scattered at sea beyond Israeli territorial waters. The record closes. The disposition. Language. Hannah Arendt attends as a reporter for The New Yorker. In 1963, those essays become Eichmann in Jerusalem. She does not contest the evidence or the verdict. She rereads the performance. Eichmann does not speak in demonic fury. He operates in administrative normality. Her claim is not that the crimes were banal, it is that the man was ordinary, and that mass killing can be organized in an ordinary voice. That is why the argument persists. It removes the comfort of obvious monstrosity as the only warning sign. The danger is not only what is believed, it is how it is carried. Epilogue: The Record. The Jerusalem trial built a bounded arena: indictment, testimony, judgment, appeal, sentence. It did not resolve history. It fixed responsibility in law. What remains is the record, what it looks like when just doing my job runs out of oxygen. Here, the collapse was not quiet. It was recorded in open court,